Hey, welcome everyone. Thank you so much for taking time out of your day to join us. My name is Jordan Diamond. I'm the president of the Environmental Law Institute and really thrilled that you are all joining us for this important conversation. Before we dig into our panel, and I promise not to take up too much time, but before we dig in, just a few quick housekeeping announcements. First, we do have a large number of people joining today. If you have any technical difficulties, any difficulties of any kind, please reach out to Madison Calhoun at calhoun@eli.org. That's CALHOUN at eli.org. The second is a format note about this panel. We are going to be largely engaging in conversation. We will reserve the final quarter for questions from the audience, but please don't think you need to hold your questions until the end. Again, there are a lot of people joining today, so the quicker you can get your questions in, the better chance we have of being able to address them. Okay. With that, let's actually turn to the panel. So as all of us know, just under 2 weeks ago, the Supreme Court handed down a major ruling in the environmental law and specifically climate change law arena. Whether you have read the West Virginia EPA opinions or just some of the commentary around it, you likely already know the basics. This panel will go over those fundamentals briefly to make sure that we're all starting from the same page, from a common foundation. But then we will quickly step away from the procedural history and into the realm of what does this mean? Where are we headed next? What are the paths laid out? How do they vary from before? And what are the questions we face as we move ahead? So I just wanted to join and welcome everyone for what I believe is a truly critical conversation, and to thank all of our panelists today for taking the time out of their day to speak with us on this breaking news panel, and to all of you for recognizing the importance of this conversation. I will now turn things over to Kate Bowers, who has kindly agreed to moderate the discussion today. And she will introduce all of the other speakers, but I will just quickly note, Kate is a legislative attorney in the American Law Division of the Congressional Research Service. Prior to CRS, Kate spent nearly a decade in the Environment and Natural Resources Division of DOJ, most recently as a senior attorney in the Environmental Defense Section. Following her earning of degrees from Yale and Harvard, she also clerked for the Honorable John Padova in the Eastern District of Pennsylvania. So Kate, thank you so much for agreeing to moderate today's session. We greatly appreciate it. And I will now go on mute and over to you to facilitate the conversation.
Great, thank you, Jordan, so much for that introduction. And thank you everybody for joining us today. We have a lot to talk about, and I will jump as quickly as I can into just some foundational background to get us all situated. Before I do that, I would like to just introduce the panelists. We've got a great group of people gathered today to talk about this case. I'll start with Stacey Halliday. Stacey is a principal at Beveridge and Diamond, where she co-leads the firm's environmental justice practice group. Her practice includes advising clients across a variety of sectors on issues, including corporate governance, ESG reporting, product stewardship, federal environmental investigations, and EPA enforcement. She previously served as special counsel in EPA's Office of General Counsel, where she worked on congressional oversight and external stakeholder management, including as part of EPA's response to the Flint drinking water crisis, the U.S. Commission on Civil Rights investigation into EPA's Title VI program, and efforts to advance international and domestic climate and sustainability goals. We also have Lisa Heinzerling joining us. Professor Heinzerling, is the Justice William J. Brennan Jr. Professor of Law at Georgetown University. She specializes in administrative law and environmental law. She's the author of several books, including Priceless, on Not Knowing the Price of Everything and the Value of Nothing, a critique of the use of cost-benefit analysis in environmental policy. She has received numerous teaching awards and awards for scholar teachers at Georgetown, as well as awards related to her scholarship and advocacy in environmental law. Notably for our discussion today, Professor Heinzerling was the lead author of the winning briefs in Massachusetts versus EPA, in which the Supreme Court held that the Clean Air Act does give EPA the authority to regulate greenhouse gases. And in addition to her service at Georgetown, Lisa was also the Senior Climate Policy Counsel to the Administrator of EPA in 2009, as well as the Associate Administrator of EPA's Office of Policy in 2009 and 2010. Matt Leopold is not on yet, but should hopefully be joining us soon. He is a partner at Hunt & Andrews Kurth, where he advises clients on federal, state, and regulatory issues. He, before joining Hunton, most recently was general counsel at EPA, where he counseled on the development and defense of the most significant regulations proposed by the agency, including, again, relevant for our discussion today, the Affordable Clean Energy Rule, but also the Navigable Waters Protection Rule, the Safe, Affordable, Fuel-Efficient Vehicles Rule. And he was personally involved in defending several cases during his tenure there. Prior to serving at EPA, Matt was the chief attorney at the Florida Department of Environmental Protection and was also an attorney at the US DOJ Environment and Natural Resources Division. And next we have Vicki Patton. Vicki serves as the Environmental Defense Fund's general counsel. She leads its US legal and regulatory initiatives. She's worked for over 30 years with partners to secure national and state protections, addressing climate and air pollution. She's participated in numerous successful climate and clean air cases, and she's testified before congressional and state legislative committees. Before joining EDF, she served in EPA's Office of General Counsel, where she implemented the historic 1990 Clean Air Act amendments and received the Gold Medal for exceptional service. She's also a co-founder of Moms Clean Air Force. She serves on the boards of ELI, Earthshot, and the Initiative on Climate Risk and Resilience Law. And in 2013, she was inducted as a fellow of the American College of Environmental Lawyers. And finally, we have Kevin Pollenkars. Kevin co-chairs Covington's environmental and energy and ESG practices. He has represented a coalition of major power companies in this case, and he argued the main statutory point on which the DC Circuit vacated the repeal of the Clean Power Plan. He also argued the statutory question in the initial en banc argument in the DC Circuit back in 2016. And Kevin will be teaching the Climate Law and Policy course at Stanford Law School next year. So with that, I'll get into a quick overview of the case. Many of you are probably familiar with West Virginia versus EPA, but just to start with the fundamentals, this is a case that has significant implications for US environmental policy, climate policy, for Congress's ability to delegate authority over significant policy decisions, and for executive agencies beyond just the realm of environmental protection to carry out programs related to those significant policy decisions. So West Virginia is about 2 EPA rules that set emission guidelines for existing fossil fuel-fired power plants. The first of those rules is the Clean Power Plan, or CPP, which EPA issued in 2015. And the second of those rules is the Affordable Clean Energy Rule, or the ACE rule, which EPA issued in 2019 and which replaced the CPP. EPA issued both of those rules under Section 111 of the Clean Air Act. And as part of the Clean Air Act's overall scheme to limit pollutant emissions for stationary sources, once EPA makes an endangerment finding, once it identifies air pollution which may reasonably be anticipated to endanger public health or welfare, the agency then has to identify source categories that contribute to that pollution. And it also has to set emission guidelines for states to set standards of performance for existing stationary sources in those source categories, to the extent they're not already regulated under several other Clean Air Act provisions. Now, Section 111 does also require EPA to develop performance standards for new sources. I'm not going to go into that right now, just because this case does focus on what EPA does to regulate existing sources under Section 111. So once EPA issues those emission guidelines, states then use the standards to develop plans to establish standards of performance for existing sources that are in their jurisdiction. For both new and existing sources, EPA's regulations have to reflect the emissions reductions that are achievable through application of something called the Best System of Emission Reduction, or BSER or BESR. The statute doesn't actually define that term though, and a lot of the debate around EPA's regulations centers on the scope of EPA's authority to determine the BSR for existing power plants. In general, EPA identifies and evaluates the adequately demonstrated systems of emission reduction for a particular source category to determine which is the best, and then it sets emission standards based on that best system, taking into account cost, non-air quality, health and environmental impact, and energy requirements. So in 2015, EPA finalized the Clean Power Plan, and in the CPP, EPA identified the BSR as a combination of 3 building blocks. The first one was improving the heat rate at coal-fired units. And the second and third blocks employ what we call generation shifting. So that's just shifting electricity generation from higher emitting sources to lower emitting ones. So the second building block was shifting generation to lower emitting natural gas units. And the third building block was shifting generation from fossil fuel units to renewable energy generation. And when EPA issued the CPP, it explained that the best system was one that applied to the overall source category. The CPP was issued in 2015, but it never took effect. It was challenged in the DC Circuit, and then before any court considered the merits of the rule, the Supreme Court stayed its implementation pending judicial review. EPA repealed the CPP in 2019 and issued the ACE rule. And in that rule, EPA adopted a narrower interpretation of its authority under Section 111. It said that the only permissible reading of Section 111 limited the BSR to control measures that could be applied at a specific source. Various states and stakeholders promptly challenged the ACE rule and the repeal of the CPP. And on January 19th, 2021, a 3-judge panel of the DC Circuit vacated the ACE rule and the CPP rule in a split decision. The DC Circuit, though, did later agree to grant a stay of its vacature while EPA considered its regulatory options. The Supreme Court then granted review to consider whether Congress constitutionally authorized EPA to consider control measures that could be implemented beyond a specific emission source when it determined the BSR and set emission standards under Section 111D of the Clean Air Act. That gets us to June 30th, when in a 6-3 decision, the Supreme Court held that EPA exceeded its authority in the Clean Power Plan when it based its emission guidelines on generation shifting. The court analyzed EPA's interpretation of Section 111 under something called the Major Questions Doctrine. Now, prior to West Virginia, the court had never actually referred to this doctrine by name in a majority opinion. In concurring opinions, yes, and in a lot of scholarly commentary around the court's use of the doctrine. But what we saw was that in a handful of cases going back over the past 3 decades relating to challenges to agency action, in some cases the court had rejected claims of agency regulatory authority under this doctrine when the underlying claim of authority concerned an issue of vast economic and political significance, and where Congress had not clearly empowered an agency to address an issue. And in several recent cases this term, the court had signaled a heightened interest in applying the Major Questions Doctrine to the review of agency actions. So a lot of commentators thought that this might be the case where the court more formally described some of the contours of that doctrine. And in West Virginia, the court explained that when there is something extraordinary about the history and breadth of the authority an agency asserts, or the economic and political significance of that assertion of authority, the court should hesitate before concluding that Congress meant to confer such authority. And in those circumstances, an agency now has to point to clear congressional authorization for its action. And in this case, the majority held that there was a major question. And the court focused on the notion that EPA's generation shifting based approach would implicate coal-fired plants' share of national electricity generation. And the court cautioned that EPA could conceivably extend its authority under Section 111 to force existing coal plants to cease generating power altogether. The court concluded that it was unlikely that Congress would task EPA with balancing the many vital considerations of national policy implicated in deciding how Americans will get their energy, such as deciding the optimal mix of energy sources over time and identifying acceptable levels of energy price increases. The court, in reaching this conclusion, described Section 111D as a previously little used backwater and underscored that prior limits set under Section 111 had been based under source-specific pollution control technology. Justice Gorsuch wrote a concurring opinion focusing on the nature of the major questions doctrine. Justice Kagan dissented. She argued that Section 111 did in fact confer a broad enough delegation of authority to permit the generation shifting that had been set out in the Clean Power Plan. A lot of really interesting nuances in those concurring and dissenting opinions. I think we'll probably get to some of those in our discussion today. But with that basic framework, I would like to start going into some of the questions that I have for the panelists, as well as some of the questions that that viewers will hopefully be submitting. I do want to start with just some questions about what this case means. Kevin, I'm going to tee the first question off for you. I think there's been a lot of confusion in conversations about this case about how generation shifting as a concept overlaps or differs from the idea of regulating inside the fence line or beyond the fence line. Are these distinct concepts? What did the majority opinion actually say about these concepts? And following this opinion, what did the court actually take off the table in terms of pollution control measures that EPA can identify?
Well, thanks, Kate, and it's a pleasure to be here. I think it's important to start by clarifying what the court did not decide, just really quickly. They did not decide that EPA doesn't have the authority to regulate greenhouse gases. That was a real concern, that they could decide that and renege upon the view in Massachusetts v. EPA, given that some of the petitioners and their supporters actually actively teed that up, a revisitation of Mass v. EPA. And recall that Justice Roberts dissented in Mass v. EPA, and the only member of the majority in that case who was still on the bench was Justice Breyer. And so there was some concern that that could be taken up. The court did not reach that. The court also did not decide that the Trump administration's view of the statute was correct. They did not decide that all EPA is limited to in setting what is the standard based on the best system of emission reduction is things that can be done at or to an individual generating unit. The Chief Justice went out of his way in the opinion to say they're not deciding whether the best system refers exclusively to measures that improve the pollution performance at individual sources, such that all other actions are ineligible. All they decided was that the way the best system was set in the Clean Power Plan and the way generation shifting figured there, without some scientific, they said, or objective quantum to determine what was the appropriate level of the cap, but what the court viewed as just an arbitrary determination of what the level of coal generation should be, that was problematic. And so as a result, what the court has taken off the table is setting a standard that is based upon shifting generation to cleaner sources. It did not take off the table setting a standard that results in generation shifting. It was very clear that incidental generation shifting is okay. And that's an important point, because there was some fear they could go there and say that anything EPA does that necessarily changes the mix of generation is problematic. They didn't say that. The other thing that's really important to understand is that the one thing that is preserved, in my view, under the court's opinion, which was very important to my clients, is the potential availability of emissions trading and averaging, things that are distinct from an inside the fence line approach like the Trump administration espoused, where they said you can't even trade or average emissions for purposes of compliance. The court left that open, and they discussed a 2005 Bush era rule, the Clean Air Mercury rule, as different than the way generation shifting functioned in the Clean Power Plan. There was a cap and trade program set for mercury emissions, and it was set based upon available technology, and the court implicitly acknowledges that that might be okay. And so that's very important, because one of the reasons my clients sued is because The straitjacket interpretation that the Trump administration espoused took off the table emissions averaging and trading and cap and trade and all these things that have long been used by the power sector. So that's what I'll start with, Kate, but what really stands out to me and what's important to clarify about the boundaries of what the court did. I know there's a lot of hand-wringing out there, but when it comes to EPA's authority, the court was very, very narrow in what they were taking off the table. Now, how they got there, pronouncing the major questions doctrine, that is a big deal. And I don't mean to undersell that, but that's a separate question about what the court left for EPA in regulating greenhouse gases from power plants.
Thanks, Kevin. And we will definitely get into some questions about the major questions aspect of the court's holding and what that might mean going forward for EPA, but also for the executive branch at large. I want to ask Stacy the next question. Kevin kind of helpfully explained some options that the court's decision might take off the table in terms of regulating greenhouse gas emissions, at least under Section 111 of the Clean Air Act. From an environmental justice perspective, how is the availability of different regulatory options going to be playing into the Biden administration's EJ strategy, particularly going forward now?
Yeah, first, thank you for having me on this panel. It's great to join this incredible group of folks. I think from the environmental justice perspective, this is introducing a lot of uncertainty. I think as Kevin underscored, the really big question, introducing this major questions doctrine, there's no federal law for environmental justice, right? So there's no big statute that says environmental justice explicitly, but we've seen a real focus on the federal stage, particularly accelerated by President Biden's prioritization of environmental justice alongside climate. So I think, we're going to see some more creative strategies here in terms of incorporating environmental justice and some work that EPA is doing. But fundamentally, I think a lot of the tools that the Biden administration is using won't necessarily be threatened here. I should note that, ultimately, as we saw in the IPCC 2022 report, climate impacts disproportionately impact marginalized communities, bottom line. So, the long-term impacts of this may, significantly impact marginalized communities in that way. But today, I think tools like enforcement, if you look at the strategies that EPA can use through setting emission standards within NACs, EPA just released this amazing, it's the updated version of their legal tools that looks very creatively at how they can use existing authorities and their rulemaking abilities to incorporate environmental justice. So that creative use and incorporation of environmental justice, use of enforcement, the transparency that we're seeing now with greater mapping tools to empower communities with the expansion of data and monitoring, I think that's something that's going to be a huge tool that will still continue moving forward for environmental justice. And then obviously, I think we might see more activity in the state level, sort of a perceived, the sort of hanging, a perceived hit to environmental justice. We might see more activity in the state level pushing this forward. And, I don't think we should undercut what we're seeing from investors as well. There's, this last proxy season, there's been demand for environmental justice and racial justice audits. So there's a lot moving forward, I think, in a variety of sectors that won't necessarily be hindered by this, but the major questions doctrine, the hit to administrative law and that uncertainty may bring some other challenges down the line.
Great, thank you very much, Stacey. Appreciate your perspective on that. The next set of questions I'm going to ask Lisa are for you. Kevin talked a little bit about the distinction between EPA requiring generation shifting or setting the BESR based on measures that would have an incidental effect of resulting in generation shifting. So Justice Kagan in her dissent described generation shifting as one tool in the pollution control toolbox. If there are now some limits on EPA's use of that tool as a direct matter, what other regulatory options do you see as available to EPA that you think the agency can really rely on for regulating greenhouse gas emissions from either coal-fired power plants or from other sources?
I might put the question slightly differently in the sense that I think that EPA will be on firmest ground in regulating air pollution under long existing programs that do offer a huge amount of environmental protection in a huge number of ways. So unfortunately, just to take the sources at issue in West Virginia versus EPA, that is power plants, fossil fueled power plants, they have an enormous effect on human health and the environment that even goes beyond the effect of greenhouse gases. And they can be controlled indirectly through setting stricter national ambient air quality standards. They can be controlled through controls on their hazardous discharges to water, to their hazardous accumulation of and disposal of their own waste products like coal ash. And so there are a lot of ways in which these sources can be controlled, and that those controls often have the effect of limiting both emissions at these plants, but also limiting the operation of these plants. And so it strikes me that one thing that's obvious is that the Supreme Court is telling us we sort of like the old programs the way you used to run them. And there are a lot of opportunities under those programs. The one caution I would raise, and I don't know how paranoid I'm being about the Supreme Court today, but the word incidental sort of nags at me. So I wonder that if the court said, well, you can cause generation shifting as the incidental product of some other kind of regulation. And so all the regulations I've mentioned may cause generation shifting insofar as they clamp down on fossil fueled sources. But my worry is that if the EPA says what is true, which is that you can control a lot of different kinds of pollution kind of at once, these sources are bad in a lot of different ways for the environment. If they openly say that, and they say, look, we're regulating particulate matter today because it's a lethal pollutant that kills millions of people around the world and many, many, many thousands of people in this country. And they say, and also, doing what we're doing will also control, have the effect of limiting greenhouse gases. My worry is that that word incidental will come up and bite EPA if they talk about climate change in addition to the other things. And I don't mean to say this in a strong way, like EPA should never say the words. I think that's terrible, but I think it's a mark of how both aggressive this Supreme Court seems, how, to me, untrustworthy it seems, and how worried we should be in the aftermath that that just talking about climate might get it into trouble. I'll just say, in addition, and then I'll close there. It is very striking to me that the Supreme Court, in this opinion, both the majority opinion by Chief Justice Roberts and the concurrence by Justice Gorsuch, mention things like congressional testimony, press releases from White House, from environmental groups, and White House fact statements in describing how major this question decided by EPA was. And that's where it makes me a little bit scared about how much the court is going to drill into statements made on the outside about how important EPA is and what they're doing. And that's, again, where that word incidental makes me worry that if there's any hint from any of those kinds of documents that the EPA is consciously adopting a policy of reducing greenhouse gas emissions, that the agency might get in trouble.
Thank you, and thank you for drilling into how the court was using the word incidental. I think there is some ambiguity and some potential for pushing that in different directions moving forward. The next question I'm going to ask is for Matt, who is going to be joining us by phone today. So Professor Heinzerling just talked about some of the regulatory options that would be available to EPA going forward. Matt, I was hoping that you could talk about what other regulations are on the horizon coming from EPA and regulating these sources, and can we expect those rules to be affected by this decision?
Thank you, Kate, and apologies, I can't be on video. I have computer issues. But I think, a couple points a lot of important points have been made, and most of which I agree with, and you know, but I think at the outset, you know, this decision certainly potentially is the most important administrative law decision since Chevron, in my opinion. And I think we're going to get into how it may or may not interact with Chevron, but it was notable that the majority didn't even mention Chevron. So that's an interesting issue. As to what's left for EPA and what they do going forward, I agree the fundamental power to regulate greenhouse gas is undisturbed. But the court did get into how to regulate, not only whether, but how, and they determined the how under 111D was a major question, certainly. And the opinion is specifically discusses a couple different things that EPA might do on remand, which is fuel switching, and to the extent what is possible is probably an open question, but I will note that the court in a footnote says that it cannot recharacterize a coal plant as a natural gas plant. And so clearly technological solutions applied at the source seem to remain in place. And I would say cap and trade, however, as a best system of emissions reduction is not available after this opinion, but it may, as Kevin pointed out, it may or may not be available as a compliance methodology if a state wants to issue a plan to comply with the best system of emissions reduction, and not in some kind of creative manner. But I will note the court did say and referred to the mercury rule, which the government had argued was an example of cap and trade that EPA had used under Section 111, and it referred to that as potentially dubious or unavailable as an approach. And although the mercury rule was reversed on other grounds. And so looking at that and looking at where to move forward, I think, you know, Professor Heiserling points out that trying to do something directly or making big pronouncements about a transformative rule, if it's not a clear statement in that particular section of statutory authority, is ill-advised for administrative agencies, you know, EPA and others at this point. And when they are, but, you know, getting at climate change using traditional authorities, one would think of, you know, things still available under the Clean Air Act that were untouched, for example, is the CASPER program, or no direct impact necessarily. And the court treats each section of the statute differently. And where it authorizes cap and trade, for example, under the acid rain program, it's permissible, but it's not going to infer a large power like that, you know, unless it's expressed. So I think EPA will continue, you know, to, in my thinking, hit singles and doubles, and maybe not swing for home runs to address the climate crisis. But it's certainly, in my view, a shot across the bow of the whole of government approach to addressing climate change. When you're trying to enlist every single agency in the government, potentially when they've never attempted to regulate climate issues before. And maybe we'll talk about a little bit later some of the rules that might be affected in that effort.
Great, thanks, Matt. And I was hoping that somebody would would talk a little bit about what this means for that whole of government approach to combating the climate crisis. I know at the time when President Biden took office, we heard some advocates say that every agency is a climate agency now. And I think that there are some questions about what this may mean, going forward. Vicki, I'd kind of like to hear from you on that question. To what extent do you think other agencies beyond EPA have the ability, following this decision, to issue regulations to address climate change?
Thanks so much, Kate. I'm going to just briefly touch on some of the comments that have been made about the scope of EPA's authority and then turn to that important question. Power plants in America discharge 1.5 billion tons of climate destabilizing pollution every year. That is the reason we're talking about power plant pollution. And the reason the Environmental Protection Agency relied on generation shifting in determining the best system of emission reduction that is adequately demonstrated, relying on a very careful assessment of the statute. And I encourage everyone to read Justice Kagan's dissent because it carefully assesses the statute, unlike the majority opinion, which is which does not, and is because that matters. 1.5 billion tons of climate destabilizing pollution matters, and it matters to everyone in our country. That makes power plants not only one of the largest single sources of climate pollution in our country, it makes it in the world. And to be clear, EPA continues to have the responsibility to protect the American people from climate destabilizing pollution, including power plants, including new power plants. Today in America, we have new gas plants that are being built at large volumes, extensive capacity additions that are not addressing the heavy burden that they impose on the American people in terms of climate pollution. That's also an economic opportunity. We continue to need to address oil and gas methane, which is an enormous source of harmful pollution, and we can do it in a way that will also have profound benefits for communities and neighborhoods. There are communities and people who are afflicted by this pollution, and they will have enormous benefits if we roll up our sleeves and if EPA completes its important work to address existing source oil and gas methane pollution, as it has a responsibility to do. Vehicles are an enormous source of climate destabilizing pollution. EPA continues to have a responsibility to tackle and address the climate pollution from vehicles. The good news for our country is that all of those can be addressed in a way that creates jobs, that creates economic opportunities, and that provides greater justice and benefits in terms of healthier air, safer communities. And so we've got a lot of work to do, and we can't let this really damaging opinion take our country in the wrong direction. There are a couple of other elements of the court's decision that are really important. One is that the court settled some long contested issues, Kate. And what some of those long contested issues include questions about whether when EPA issues new source standards under Section 111B, there's also a responsibility for EPA to tackle existing sources under 111D. The court said yes. There's also been long contested questions about whether 111D standards are binding. There have been some who've argued for a long time that just some of the statutory factors set forth in 111D mean that they're not binding. The majority opinion says they are. When EPA establishes those emissions performance standards, they need to be met, they need to be achieved. And of course, we need to be addressing climate change in every way we can, right? It is a systemic challenge. It is a systemic threat to life on Earth. And so, yes, does the HHS need to be ensuring that it's protecting workers and people and who are harmed by heat illness? You bet, because we're going to see increasing heat illness and heat distress. Does the Department of Energy and the Department of Transportation need to be making investments and ensuring, consistent with the bipartisan infrastructure legislation, that we're modernizing our transmission to bring renewables to load centers? You bet. Investing in new charging infrastructure? Absolutely. All sorts of things that we all need to do to help address the climate crisis. And for all of the participants in today's webinar, join, ELI's pro bono network. ELI has a pro bono effort to help tackle both environmental justice and help move our country forward. We all have a role here. This is an urgent challenge.
Thanks so much, Vicki. I'd like to shift gears a bit and really start digging into the major questions doctrine, since that was it was not just central to the court's holding here, but I think will be of continued relevance to the court's review of significant regulatory actions in the environmental sphere going forward. So, Vicki, I'd actually love to just start with you. How do you read the court's reliance and the centrality of the major questions doctrine in this ruling as impacting likely future efforts to regulate greenhouse gas emissions?
Yeah, just briefly, Adrian Vermeule has an important op-ed in the Washington Post where a very conservative scholar, Adrian Vermeule, right, says there is nothing conservative about what the majority has done. It doesn't reflect originalism, textualism, judicial restraint. You find the textualism, you find the careful assessment of the breadth of EPA's authority in the dissent, right? You find sort of the critique of the court having reached out and taking a case that really wasn't appropriate for judicial review. That's addressed in the dissent. What does that mean? That means we have a judge-made doctrine that creates uncertainty that hurts our country. When Justice Kavanaugh was in the DC Circuit, he wrote a dissent from the denial of rehearing en banc in the net neutrality case in 2017, where he said, you know, this major questions issue, kind of you know it when you see it. Well, that's not a way for our country to tackle big challenges, right? The way for our country to solve the climate crisis is to have the environmental law that we've long administered for decades that is designed by Congress, designed by the people's representatives to be adaptive to new science, to be adaptive to new technologies and new solutions, to help our country tackle these problems, not some uncertain, you know it when you see a judge-made law that creates, I think, enormous uncertainty and that hurts our country in achieving environmental protections, environmental outcomes, and hurts businesses that are trying to make investments.
Thanks. I'll ask one or two more questions, and then I would like to also throw it open so that the four of you can respond to each other a bit. Vicki, you just talked a little bit about some of the distinctions that folks have identified between the majority opinion and Justice Kagan's dissenting opinion in West Virginia. I also found Justice Gorsuch's concurring opinion interesting, and he's a justice who has taken a really keen interest in this doctrine. He's written concurring opinions now on major questions in multiple cases this term. Kevin, I want to ask you if you'd like to talk a little bit about the daylight between the majority and the dissenting opinions. And do you think that Justice Gorsuch's position on major questions is going to become more prominent as the doctrine continues to evolve?
Well, thank you. It's really interesting, the daylight between the majority opinion and the concurrence. If you read the concurrence, you know, what the majority opinion did that's really big in announcing the major questions doctrine by name is say that this is rooted in the separation of powers. There, in the cases from the shadow docket concerning vaccine mandates, concerning basically the CDC's eviction moratorium, they never talked about that. They applied the major questions precedents, but they didn't really elevate it that this is a quasi-constitutional question rooted in the separation of powers. And that's a different question. We thought we were doing statutory interpretation, as Kagan's dissent expresses. We thought what we were talking about was the language of the text and what is a plausible interpretation of the text. And what the majority's opinion says, it really doesn't matter what a plausible interpretation is in these extraordinary cases. What Gorsuch's concurrence does, which is different, is he roots the major questions doctrine almost as a corollary of the non-delegation doctrine, that long believed to be dead doctrine that he would like to revive based on a number of concurrences and dissents that have been written, to basically say that a blank check authority that's written to an agency, even if it is Congress telling EPA to protect public health and the environment, is unconstitutional per se under the non-delegation doctrine. I mean, and think how far that is from where we were just over a decade ago when this court in AEP versus Connecticut decided that Congress delegated to EPA the authority to decide whether and how to regulate greenhouse gas emissions from power plants. And now we have a concurrence that basically says, I agree with the majority's outcome in getting to this conclusion of application of the major questions doctrine. And it's because there is no clear delegation of authority for EPA to do big things on climate. And so the way I read Justice Gorsuch's opinion, and he lays out some criteria that aren't enumerated in the majority opinion for when and how the major questions doctrine applies, the best you can get out of the majority opinion, this may be underselling it, between the majority opinion and the dissent, is it's a raised eyebrow test. Something like a know it when you see it, whereas Justice Gorsuch more methodically, without engaging with the text, tries to establish some principles of how this is rooted in the separation of powers, how this is a constitutional question implicit in the vesting clause, he says. And that's the real significance of the concurring opinion. And a really significant point is that it didn't end up in the majority opinion, but he has very clearly signaled where he is interested in going. And based on some of the pronouncements of Justice Kavanaugh and others, there could be an appetite to further expand the boundaries of the non-delegation doctrine qua the major questions doctrine.
Thanks, Kevin. You talked a little bit about non-delegation and major questions. Another issue is major questions and Chevron. This majority opinion didn't refer to Chevron. Matt, I think you were the one who mentioned that. And I would just open this up to any of the panelists. How do you think courts are going to be kind of deciding what framework to use when they review potentially significant environmental regulations going forward? What does this mean for Chevron deference?
Kate, I'll jump in and give it a shot, and happy to have others as well. What I see in the majority opinion is that how major questions interacts with Chevron is it's an antecedent to Chevron. It's something that the agency should apply when setting out to regulate a particular issue. They have to first clearly identify authority, a sufficient delegation from Congress. It's a clear statement rule. That's a starting point. And I think there are a number of cases, as you know, starting with Brown and Williamson tobacco, all the way through UARG, and then the COVID cases that the court cites to, that you don't even get to Chevron. You don't get to a question of ambiguity about the delegation and the scope and range in which an agency may interpret and fill gaps. Because I think one thing everyone would agree on is agencies are necessary. They need to fill certain gaps, and particularly EPA with very technical subject matter, sometimes science-based, health-based, things that Congress is not going to tackle or may not be well situated to tackle. But what this case is about is just because something has been delegated, the starting point for a court, and I see this playing out really in the lower courts now going forward, is what's the scope of that? Because the court will now approach some big projects that aren't explicit within the statute with skepticism, rather than an assumption of a broad delegation to the agency. And I think you're going to see a lot of advocates raising major questions in lower courts, rightly or wrongly, and we'll have to see on how that plays out. But it seems like a de-emphasis in my mind of Chevron and the traditional analysis, although it's certainly still there. And when you get past major question, I think you get back into the traditional realm of Chevron.
May I say something? I think the court's opinion in West Virginia is important as much for what it doesn't talk about and seems to be reluctant to talk about as for what it does talk about. It doesn't talk about non-delegation, and as Kevin said, it talks about separation of powers principles. That's non-delegation, right? For some reason, the majority didn't want to say it, but that's the only separation of powers principle that really could be at play here. Chief Justice Roberts, Justice Gorsuch, Justice Alito have all joined opinions talking about reviving the non-delegation doctrine and reviving it, even its connection to the major questions doctrine. So it's really important to recognize that for some reason the court is being coy. It's not telling us exactly what it's doing, but it's doing it. And so the non-delegation doctrine looms. And likewise, with Chevron, the court has just stopped mentioning Chevron altogether. People have stopped asking for Chevron deference. The court hasn't deferred since 2016. I don't think it's West Virginia that killed Chevron by any means. It's just one more piece of evidence that the old style Chevron with its generous deference to agency interpretations is just no longer with us. And you can see this in other opinions for this term on statutory interpretation that would be perfect locations for a discussion of Chevron, either for deference or after it, and you just don't see it. And so to me, this decision in terms of Chevron is sort of a piece with what we've seen. I think it is also of a piece in not explicitly saying that. So as with non-delegation, the silence with respect to Chevron leaves it in a state of real uncertainty. And what I worry about is the Supreme Court has unleashed the lower courts to rule now in cases with maybe a hostility to deference, certainly an eye on major questions, and has, through its shadow docket, shown an incredibly aggressive willingness to reach down and either stop or affirm lower courts if they're doing something it doesn't like. I mean, arguably, I think that today's shadow docket actually started with the stay of the Clean Power Plan in 2016. Which happened on the shadow docket, and we have every reason to believe involved major questions. And so it just strikes me that this decision, again, kind of shows us what we probably should already know, is that Chevron, as we knew it, is no longer with us.
Thank you, Professor Heinzerling. And that actually, that ties into, I think, a couple of the questions that we've seen in the chat panel so far. We've had some questions about what you as panelists think might be the next big environmental case where major questions comes into play. You know, we certainly have Sackett versus EPA coming up next term, where the court has been invited to revisit Rapanos and an aspect of the definition of waters of the United States. And we have another attendee has made reference to the Texas Attorney General making a filing recently in the Fifth Circuit citing the major questions doctrine. Do you see a likely case or cases where that could be a vehicle for further discussion of the doctrine up to the Supreme Court?
I think you mentioned it, that there's a Texas versus EPA case in front of the DC Circuit that, you know, I'm involved in, Vicky's involved in already, where the Texas AG and other Republican AGs have, in their non-binding statement of issues, raised the major questions doctrine, challenging EPA's authority to set standards for light-duty vehicles that are premised upon what they view as an implied EV mandate. And notably, in that case, on the same side as us are all the automakers. And yet the challenge is being brought that just like EPA can't cause a shift of generation to new renewable sources, so too EPA, in deciding what is the appropriate standard for tailpipes, can't decide to outlaw the internal combustion engine or require the production of EVs. That is a question of the quintessential policy-like question that Congress should be answering. And so we are going to be briefing that. We got an order in a related case this morning to set a briefing schedule. We still haven't gotten the order to brief in that case, but I am certain that that issue is going to be raised, and whether it receives a warm or hostile reception from the DC Circuit, it likely will go up to the Supreme Court, and we'll be asking similar questions. We'll be asking questions of like, well, isn't this what EPA has always done? They've always been regulating tailpipe pollution. just like EPA has always been regulating power plant pollution. Isn't this just the direction that the industry writ large is already going? Look, most major automakers have announced an all-electric future by 2035. That's why they're on our side. The Clean Power Plan's goals were achieved a decade in advance, even though it never went into effect. That's why Kagan points out that my clients were on the side. That didn't matter to this court in deciding what was a major question. And so I really do worry that that's one case where we are going to see this teed up again and soon.
I would just add that a better question is not all of the ways in which there will be forces out there that make major questions, assertions. It will be made in a number of instances, right? And they will be in service of really disrupting protections for the American people, protections that are really important for human health and the environment, and to ensure healthier communities. And what's crucial is that the Environmental Protection Agency continue to do its job and continue to do its important work that's reflected in extensive statutes crafted by the people's representatives after years and years of hearings and fact-finding and debate in all parts of our country that say to the Environmental Protection Agency, do your job, address these harms, do it in all of these ways, considering all of these, factors and all of these, on the best science, the best technology, engage all stakeholders. That's what we need to do. And yes, there will be lots of people who use this case to try to disrupt progress. And I think it's up to all of us to ensure that we continue to make progress in protecting the American people from the harms that environmental law was long designed to address.
Building on sorry, I think I heard Matt.
All right, you go ahead.
Yes.
Just quickly, thanks. I think part of building off of Vicky's point and what gives me just some agita thinking about it. I remember in 2016 when I was in OGC, we started talking a lot about so much of where environmental law is going are these cross-cutting issues. We need to start thinking in creative ways, not just about media-based silos. And environmental justice sort of demands that kind of thinking, sort of incorporating these considerations in ways we hadn't previously. So I think we're seeing a lot of that change now play out, and we started to see a lot of incorporation of EPA-based considerations, things like the recent HFC phase down, stuff like that, where you haven't seen, and what FERC is doing, like just changes in the way that we think about equity and incorporate it into the way that we administer very traditional environmental laws. So that progress that Vicky referenced, I think that's, for environmental justice to advance, just requires some novel thinking that may face greater challenges to folks who think that it's not as great a priority. Hopefully the states continue to move the ball forward in thinking about these important questions of equity, but I know that just inherently environmental justice is a novel area for a lot of people and not something to think about in traditional environmental law, so there may be issues there.
Kate, just one point briefly. I think the progress, really the court is pointing back to the Congress, and I think all would agree Congress should probably be legislating more in the environmental area than it has been able to, and it knows how to. I mean, clearly, when it wants to design a cap and trade program, it can do so. The court actually pointed to attempts to do that in the past that had failed. But I think Congress is going to have to take more of a leadership role to make progress on certain issues, but we also have to look at some of the proposals. I think one rulemaking that may really raise questions of major question could be the SEC's climate disclosure rule and greenhouse gas reporting rule, just because that agency has never really been in that business. And agency expertise is clearly a factor that courts are going to look at And one has to question whether the SEC has that particular set of expertise, like EPA does, for example, in its greenhouse gas reporting rule.
I think one of the things that's really striking about the West Virginia case is that it, to me, really makes clear that an agency can shrink regulatory authority but not expand it. And I don't know where the agency in the court's constitutional universe gets that power and where the court finds that kind of regulatory asymmetry. So if an agency doesn't use regulatory authority, statute doesn't grant it, right? That's one of the messages. But if it uses it for the first time and tries to be creative in all the ways that the panel has been talking about it, that's when it gets in trouble. And that really strikes me as problematic.
I would just add that by the court's own terms, this is supposed to be confined to extraordinary cases. That is the language the court uses over and over. And just to take the SEC initiative to provide investors from Main Street to Wall Street with just some basic information so they can make sound and informed decisions about climate risk. You know, the Securities and Exchange Commission has for decades and decades been requiring just basic environmental disclosures. So this is something they've been doing for many, many years. And there's an enormous amount of information in that docket, in that administrative record, from people who have extensive experience implementing the 1933 and 1934 securities law, explaining kind of the long, long history of environmental disclosures.
All I would add is that I won't speak to the specific rule and what I think about how this case aligns with that specific rule or not, is that, as Lisa pointed out earlier, the decision is suffused with Gina McCarthy saying this isn't about pollution control at all. The concurrence is suffused with the pen and a phone statement that President Obama used when he said, I told Congress, if you don't act, I've got a pen and a phone. And all of that noise about this being the biggest thing we've ever done, the most monumental, that should be tamped down if an agency wants to avoid the major questions. That's an obvious point. All of us lawyers who've been litigating these cases thought that ultimately we were arguing about the text, and there are certain principles such as failure to pass legislation usually is not looked to by a court as informative of what Congress intended or not. Here, the court brings all of that in and says this indicates how big this is. And so an agency might be wise, if they are going to employ existing tools to try to address some of these problems, environmental justice, climate change, to not issue those political announcements, to not pound their chest and say, this is the biggest thing we've ever done, but to say this is incremental and this is swimming in our lane and consistent with what we've already done. And it's so funny because we thought these were all about, lawyerly arguments. And to some extent, I think it's more about PR, because we need to make sure that the politicos don't get out there in front of the lawyers.
This is also the same court that has brought civil servants at the agencies who used to be not subject to the political apparatus, closer and closer to the political apparatus, and the same court that has been strengthening its separation of powers jurisprudence to make the president ever more powerful so that the president controls the executive branch all the way down. And the reason I mentioned that is that what Kevin was mentioning is how the court doesn't actually like it, though, when the regulatory system takes on the cast of politics, right? When the regulatory system, people in the regulatory system talk in kind of political terms. So there's a real, in my view, disconnect between the basic thrust of the court's separation of powers jurisprudence and its dislike of agency heads and presidents kind of bragging about their accomplishments.
Thank you, everyone. I see we have many interesting questions that that folks viewing this panel have submitted, and I do want to make sure that we have some time to get to those. And I apologize in advance. We may have more questions than we have time to discuss in the remaining few minutes we have here. But I'd like to start with, we've gotten a few questions about Massachusetts versus EPA. The court certainly did not revisit that holding in this case, but do any of the panelists have thoughts or comments on what this ruling and what the major questions doctrine might mean for the possibility that the court would revisit Mass v. EPA somewhere down the line?
Lisa, I think you got to take this.
I think that I don't think the court is likely to revisit the specific holding of Massachusetts versus EPA, which is that and the now narrowed holding, which is that the Clean Air Act empowers the EPA to regulate greenhouse gas emissions from automobiles under Section 202. I don't think the court is likely to revisit that. It may well, as Kevin was saying, deploy the major questions doctrine to limit the regulation that can occur. I don't know, but it's not likely, I think, to revisit that, and it doesn't really need to. It has so limited Massachusetts versus EPA's significance in some sense already by looking, since a case called Utility Air Regulatory Group, by looking provision by provision at whether the statute gives authority over the regulatory program EPA is trying to construct. And so I think but I do think, just to make one observation about Massachusetts versus EPA, I do think that comparing Mass v. EPA to West Virginia shows us the effect of the drastically changed composition of the Supreme Court. Massachusetts versus EPA, the court majority rejected the application of something like the major questions idea and said, no, we are not going to trim the statute based on the fact that this is a really big question. And so that's significant. The dissents also, notably, the conservative justices in that case dissented and said, oh, that the court should have deferred under Chevron, no less, to EPA's judgment that the statute didn't cover greenhouse gases. So you can see they would have deferred under Chevron, and now they're saying there's no power at all. And the fact that they would have deferred under Chevron, to me, just illustrates the asymmetry of the court's approach. That the conservative justices would have gone all the way toward Chevron deference when the EPA didn't want to regulate, but it denies authority altogether when it wants to.
I would just add that, Massachusetts versus EPA statutory stare decisis, and so it's really it's a precedent that is anchored in interpretation of a statute. The majority opinion in this case takes as a premise that EPA has the authority to address climate pollution under the Clean Air Act. It cites to a number of programs in which EPA does do that, including the landfill methane standards, which it holds out as noteworthy examples of rulemakings that EPA has conducted under Section 111D. And then on the separation of powers issues and the non-delegation doctrine, if you just think about sort of the journey of the court in the court's interpretation and review of the agency's health-based standards for particles and ozone that were adopted in 1997 and addressed by the court in a 2001 decision. That was a unanimous opinion by Justice Scalia, just rebuking and rejecting claims that were made that Congress ran afoul of the non-delegation doctrine in giving EPA the responsibility to protect the American people from health-based ubiquitous pollutants under the NAAQS program.
Great, thank you. Let's see, one other question that we've gotten was about whether this case has any impact on states participating in RGGI, or the Regional Greenhouse Gas Initiative.
It's a great question, and to Stacy's point, this case doesn't in any way undermine state and local governments and private sector actions to tackle climate pollution. And indeed, it only underscores the importance of those actions. And when you're thinking about addressing climate change, we need all of those solutions. And we need all of those solutions that help us tackle climate pollution and that also help ensure that we're doing that in a way that ensures that we're addressing the heavy burden of pollution on communities that have been bearing that burden for far too long. So we've got a lot of work to do at the state and local level with private sector leadership, and we need all of the tools in the toolbox to tackle the climate crisis. And the court's ruling here couldn't underscore that any more clearly.
Thank you. Any other comments on that question? I have a few more that I could try to get to in our last 4 minutes. Okay. We did get one question about mobile source regulation and about whether this decision might have an impact on EPA's ability to set fleet-wide standards that would be based on shifting sales to lower emitting BEV vehicles. Any comments on applications of West Virginia in the mobile source sphere?
I think this is what Kevin was talking about before, and about how the major questions idea has been raised there. And I just want to offer a related point to that, which is that just illustrates under major questions, a lot of the work is done by framing the problem in front of you. And so if you frame EPA's regulation of vehicles as just like they've always done, they're regulating pollution from automobiles, it might be a different result from if you frame it as requiring a certain amount of electric vehicles or banning the internal combustion engine. And so the worry to me is partly that the malleability of the standard and the fact that the standard itself turns on how you frame the question in front of you really leads to more and more discretion in the courts in applying the standard.
On this point, Kate, I would just add that, I think it's already been pointed out that tailpipe emissions were the context in which the court first recognized the EPA's ability to regulate greenhouse gas, and that remains. And, the court also affirmed indirectly Mass EPA by citing and affirming its ABPV Connecticut holding, which references Mass EPA. So I think the question here is, what's the scope of the EPA authority under 202, Section 202 of the Clean Air Act, to regulate emissions from motor vehicles or motor vehicle engines, right? And I think there are some interesting questions about, do some of the mandates coming out of California, or sales mandates under the Advanced Clean Cars program, for instance, and fleet-wide purchasing mandates coming out of California, are those the types of regulations that would require a waiver under the Clean Air Act, under the California waiver program? And are those the types of things, does that constitute regulation of emissions from motor vehicles? And if it is, are those major questions, or is that merely kind of par for the course and regular statutory interpretation questions? And one could see how this arises when EPA ultimately has to take action or not on a proposed California waiver. So those are certainly issues to watch.
Just a couple of comments on that. One is that those advanced clean car phase 2 standards that are moving forward in California are like the California standards that address nitrogen oxide pollutions from heavy duty vehicles, are really essential to protect millions of Californians who are afflicted by smog forming contaminants. They will have enormous benefits in helping California to meet its obligations under the nation's clean air laws to restore healthy air, to restore compliance with the health-based standard for ground level ozone, which has far-reaching impacts. Those are also really vital protections to help advance justice in communities that have been bearing the very heavy burden of a number of pollutants, including nitrogen oxides and diesel particulates. It is curious that there are states that are seeking to try to interfere with and prevent other states from taking actions that protect the health of their own people, and hope that we can continue to move forward to restore cleaner, healthy air for all of the people in California who are afflicted by smog forming contaminants and in other parts of the country. No doubt we'll see lots of people kind of coming up with ideas and theories to try to slow down progress, but they're really, really important efforts, and they're vital to protect the health of millions of Californians.
Thanks, Vicki. I see that we are past our allotted time, so apologies again if you asked a question and we weren't able to get to it, but I'd like to invite the panelists if they have any closing remarks to share those now.
I would just add on electric vehicles that just in the last 18 months, our country's made over $100 billion of investments in electric vehicles, and those investments are happening by the big three, by Ford and General Motors and Stellantis, formerly Chrysler. Those are investments in manufacturing jobs and tremendous economic opportunities in places like Tennessee and Kentucky and Texas and Ohio and Michigan. And it's an example of our country's ability to address kind of a major source of climate pollution, a major source of health harming air pollution, and do it in a way that creates high quality jobs for thousands of people in all parts of our country.
Building on that, just as a closing thought on the EJ front, I think, this is still, regardless of this decision, an unprecedented time for environmental justice. And I think the train has left the station. I think some of the folks at these agencies have been thinking about these issues for a long time, and they're putting those plans into action with existing authorities that, working them in to long-use tools in new ways, but ways that I think are still effective, like enforcement. And I think, in the private sector, again, the train has also left. People see the writing on the wall in a global way and are developing policies and practices in meaningful ways and changing their practices. So I think, EJ continues to march forward in exciting ways.
I'll just say I'm very troubled by and worried about this decision and what it means going forward. But I also love Vicki and Stacy's positive comments at the end of the panel, and so I won't say more than I've already said.
And just to echo some of the comments, and I think maybe we'll see in the future major questions is reserved just for the extraordinary cases as the court intended, but we'll have to see how that plays out.
Thank you very much, everyone. I will turn this back over to the panel organizers.
Yes, hello. Just thank you so much, everyone. I just wanted to give a big thank you to all of our panelists and Kate, our moderator. Thank you, Kate, Stacy, Lisa, Matt, Vicki, and Kevin, so much for all of your time, especially for planning this so quickly. We truly appreciate it. And for our attendees, if you couldn't make it for the entire webinar, the recording will be up probably in about 2 business days. So please check it out on ELI's website if you would like. Thank you again, everyone, and have a great day.
Thank you.